Do executors always need letters of administration? Imagine you're in charge of settling a loved one's estate. You might wonder, do you always need special documents to do that? Well, it depends on whether there's a will or not. If the person left a valid will that names an executor, then that person usually gets letters testamentary from the probate court. These letters are like official permission slips that let the executor handle the estate. They authorize the executor to gather assets, pay debts, and distribute property as the will directs. But what if there's no will? Or maybe the will doesn't name an executor. In those cases, the court steps in and appoints someone to manage the estate. That person is called an administrator, and they get letters of administration. These are similar to letters testamentary but are issued when there is no valid will or no named executor. Usually, the court chooses a close family member, like a surviving spouse or adult child, to serve as administrator. Getting either set of letters involves filing a petition with the probate court, providing a death certificate, and sometimes paying a fee. The process is pretty straightforward but can vary by state. Once the court issues the letters testamentary or letters of administration, the person holding them has the legal power to manage the estate. Their duties include collecting assets, paying debts, and distributing property. Sometimes, if the named executor can't serve or refuses to do so, the court might issue letters of administration with the will annexed. This means someone else will handle the estate, but under the terms of the will. For small estates, there might be simplified procedures or documents that serve as proof of authority instead of full letters testamentary. In elder law and estate planning, understanding this difference is important. If there's a valid will and an executor named, the estate process is usually smoother. The letters testamentary give clear authority to follow the decedent's wishes. Without a will, letters of administration make sure the estate is handled according to state laws, which might not match what the person wanted. So, to answer the question directly, no, executors do not always need letters of administration. They only need them if there is no valid will or no named executor. When a will exists and the executor is willing and able, letters testamentary are the official documents they will receive.